welcome to the fifth episode of the Working Life podcast, brought by the Institute of Employment Rights. I'm Donya Jeyabalasingham. I'm the Communications Officer with the Institute, and today we're really glad to be joined by Dr Antonio Garcia Munoz, who is a lecturer in labour law at the University of Glasgow, with research focusing on collective labour law and industrial relations. Recently, Antonio wrote a really fascinating blog post for the Institute on a decision made by Uber in Spain earlier this year to classify their workers as employees. And hopefully that also means accepting their role and responsibilities as an employer under Spanish labour law. We're very grateful to have you here today to talk about this. If you don't mind, if we could start with a broad approach to what happened in January, what does this change in classification of workers mean for Uber and also for riders?
So first of all, thank you very much for having me here. I'm very happy to be here today. And yeah, in February this year, Uber Eats Spain announced that they will switch their business model and they will move towards an employee-only drivers model, which will make Uber just the same as the other big companies employing drivers in Spain, because very recently all of them have moved towards this model of employees. For the workers, this is a very important change. The consequences are clear. They will become protected by labor law rights and also social security rights and protections. So this is very important for them. For the companies, they will need to operate now on a new distinct business model, but all of them will be on equal footing. So I don't know in terms of number of people employed or profitability of their business, how this will affect them in the future, but it's just that they have to comply with the rules.
Yes, yeah, well, absolutely. These platform companies emerged around over 10 years ago across the continent, really, and you sort of saw a pattern of using the classification of workers to to circumvent labour rights. How key has this decision been to the business models that platform and gig economy businesses run on?
Well, the platforms, when they came, they operate using self-employed workers. This was their business model, and this was probably the condition of their profitability and expansion at the very beginning when they started the business. And they presented themselves as technological companies doing a mediation service and so on. We all know the story. I think for them, the idea was to avoid responsibilities and risks under labor law, and that was their let's say idea of how to do business. It was new in Spain, probably was not new in some other countries, but it was not so new. This is something not many people know, but in the 80s, and we already had cases very similar to these ones for messengers and people doing deliveries on their motorcycles in the cities. Of course, we didn't have the apps back then, but it was a similar situation. And for almost 1 decade, companies have insisted in this model, and they have put forward all kind of arguments about what was different in this relationship and the independence and autonomy of the riders to choose their hours and so on, their shifts. But well, I think the courts and scholars and now also the legislator, they have shown that this was not very close to the material reality of these persons. So I think it put at risk the model of classification of workers in Spain based on the criteria we had to decide when one person was an employee or self-employed.
So in your blog piece for the Institute, you do describe this, or begin to describe it as an issue that is to do with classification, but it does go beyond that a bit, because you describe multiple attempts to address this issue, primarily in three separate ways. The first came with the Labour Inspectorate. So I thought we could start there. You begin in around 2017 with a declaration for workers in Valencia, for delivery workers in Valencia as employees by the Inspectorate. Could you maybe discuss the Inspectorate, whether it was equipped in the right way to deal with these companies and to properly challenge misclassification?
Yeah, well, the labor inspector has done a great job on this issue. I have to explain that the labor inspector is coordinated with the Ministry of Labor, and there are the Ministry of Labor put forward a priority and a strategy on how to, what is most important for a period of time, and the labor inspector focuses on this, and platform work was one of these priorities. It was before platform workers, we already had the problem of false self-employed. So it has been a topic that the labor inspector has been dealing with for a long time. It's not completely new. But the labor inspector in Valencia, they issue a report, this more than 100 pages, very rigorous report, and they assessed the material reality of the relationships of the drivers. They made interviews, they went to the working places, and they realized these persons, the reality does not correspond with self-employed persons, and therefore they order the company to reclassify them, because basically they made the company to pay social security contributions, because this was part of the problem, that these workers are not covered under social security laws. Yeah.
And was this a singular instance, or did it trigger?
No, this was a systematic strategy of the labor inspector. Valencia was the first case, but was very soon followed by other cases in other cities in Spain, Zaragoza, Barcelona, and it was strategy that developed over time. And when finally Glovo decided to change its model earlier in 2025, they owe the Social Security more than 200 million euros in sanctions. And
God, that's a lot.
Yeah.
How effective were economic sanctions in terms of achieving compliance from these large platform companies?
Not very much, to be honest. The best example is Glovo. Glovo just kept operating under their model, and even if over the years they accumulated this 200 million sanction, they were still insisting on their model, so it was not very effective as a deterrent, let's say. Also, a very recent judgment that I couldn't talk about in the blog, but it comes from the administrative jurisdiction, has decided that they don't need to pay the sanctions, because for the sanctions to produce all the effects, there is an element of guilty. And the judge found that the companies were not guilty because they really believed that they were employing self-employed. So the economic sanction, it took more than 8 years for the first sanctions to become effective. So it has not been very effective. Yeah.
I see. So that did sort of mean that there needed to be additional interventions. Mainly, the significant challenge that came after this was from the judiciary. I was wondering if you could talk a little bit about that, how the case went from first appearance to appeals and so on up to the Supreme Court.
Yeah. Like in many other European countries, at the beginning, there was a lot of uncertainty. The courts, they reached some contradictory solutions, although most courts found riders to be employees. Some other courts found them to be self-employed. So there was a little bit of legal uncertainty here. And this was what triggered the intervention of the Supreme Court. And the Supreme Court, in a case in 2020, found that an employee a rider was to be qualified as an employee, and the deciding criteria were that this person was lacking its own organization, was not in the market in its own, and was in a very broad sense, integrated in the organization of another company. It's also interesting that the courts in Spain, they have challenged the self-image of these companies as technological companies, because finally what they are doing is not developing new technologies or anything, but simply doing a business delivery, food delivery business. So this is also interesting, I find.
So on that point of how these companies identify as technology or just an interface for work for people to use, how did the court go about saying that actually they were food delivery service providers as opposed to technology companies?
To begin with, it's funny, but the labor inspector already pointed this out, and their social aim is food delivery, just to start with. And then it's true that they do something new, and is that they use a new technological development like the app to put in contact offer and demand, but is not. This is not what I mean. The activity in itself is not. You cannot detach it from food delivery, right? This is their business. What they do is they put in contact clients and customers, and they deliver food. So the courts were arguing that without the riders, this activity could not be achieved, and the riders were key for this activity, and they were within the organization. They were part of the organization. They were not external clients or external self-employed persons.
Yes, I see. And to what extent did that judgment sort of settle the issue, at least legally? Was the Supreme Court clear that they were essential and integrated and therefore employees?
It should have been very clear to everyone that that was the case, but the companies, and particularly Glovo, they resisted, and they would make the argument that this was just one judgment sentence, and also they crafted new contracts, and they would say, okay, circumstances have changed because the contracts are now different, so these findings in this judgment don't apply to the new contracts, and so on and so forth. So there was kind of clarity from a legal point of view, but still companies, they tried to make their argument that the decision of the Supreme Court was not the end of their business model, right?
Following the Supreme Court judgment, the different platforms responded in different ways, at least up until the legislature stepped in with the riders law. I was wondering if you could talk a little bit about the different responses, especially the platforms that to some degree just sort of rejected the judgment from the highest court.
Yeah, different platforms reacted differently to the judgment. There is one company, Just Eat, that they decided to switch to a model of employee only, but they already were on this model before the Supreme Court judgment to some extent. And then one other company, that is a UK company, Deliveroo, they decided to abandon the Spanish market. And the other two companies, Glovo and Uber Eats, they were the two companies that decided to resist, let's say, to disregard the Supreme Court judgment and kind of continue with their model of self-employed. It was a little bit more sophisticated than this, because they developed a hybrid model of employees and self-employed, but basically most drivers were still self-employed in these two companies.
So as I previously mentioned, there was a third attempt at intervention, and this time it was from the legislature. And this was the introduction in 2021 of the riders law, which perhaps you can talk a little bit about. It was explicitly made to address this lack of compliance that came following the Supreme Court judgment.
Yeah, if you read the introduction of the law, the explanatory remarks of the law, it's quite telling, because it says explicitly that there are new technological developments and new models of employment that are circumventing labor law protections of some groups of workers, and we have to address this. And then the law, that has only two articles, establish a reinforced presumption of employment status for drivers working for food delivery apps. So it's really tailor-made to tackle these companies. But the interesting thing about the law is that it is the result of social dialogue. So there was an agreement between the main Spanish Employers Association and trade unions and the government on the law, on the contents of the law. And it was not easy to reach. It was more than 10 months of negotiations. And of course, the employer side was divided. Although the organization finally agreed, I mean, the employers organization agreed on this, the platforms, some of them like Glovo, they withdraw from the employers organization in this agreement. They said the employers organization was not taking into account their interest, and they attempt to create a new employers organization for them that didn't fly, and the grounds on which the employers organization agreed to the new law were fair competition, because there was the precedent in Spain of the 80s and the 90s cases, and also there was already a company that was complaining with the law, as I just said. So the idea was that, okay, we need a level playing field, so we need to agree on something, and we have the Supreme Court case that anyway says something.
So once the riders law has been adopted in 2021, there's still an ongoing issue of compliance even following that, and we will revisit how that's addressed in Spain. I was interested in what your thoughts are in terms of enforcement at this point, because you've seen the regulatory body try and address it, and then the legislature and also the judiciary, and everything seems to, and even where the Employers Association is somewhat in cooperation over the riders law, there was this ongoing issue, and I was wondering if you'd be interested in commenting on enforcement in that scope.
Yeah, I think I like to think about enforcement as a very complex machinery that were interrelated tools and strategies, and I think each of them is important. And the problem, as we know very well with labor law enforcement, is that it's difficult. It's difficult, it's costly, and it's easy for the companies to just not to comply with the law many times, no? If enforcement depends on courts, then you need someone that goes to court, and many times workers don't go to court. If enforcement is limited to an economic sanction, then the companies can make a rational calculation and decide whether this is worth or not, and they may decide to go on with their business model, as you know very well in the UK in recent cases. So I think the intervention of criminal law, unless although it sounds a little bit extreme, it's just part of the machinery to keep it serious, to keep it like working. So if you don't comply when you have the opportunity, if you don't comply with economic sanctions and so on, and judicial decisions, then the possibility that criminal law can intervene, I think it's the last resort the state has to make its own rules credible.
Yes, I see what you mean. I was quite interested in this idea you touched on, which is that there's the initial issue of a lack of enforcement means that the protections, the rules you put in place aren't executed as you want them to be, but it also has a secondary eroding factor on the state and the law's authority to make rules and to expect them to be sort of followed in a way, especially the protective ones. I suppose I'm interested in what the constitutional angle on that would be from your perspective.
Yes, I am very interested in this problem now, because at some point it became explicit, and the Ministry of Labor, Yolanda Díaz, she said publicly, it's not anymore about employment status, it's not anymore only about the riders, it is about the rule of law, it is about the rules in a democratic society, right? So I think from a constitutional point of view, you always have this tension between freedom of enterprise and the right to work. And I think if there is a tension because there must be probably a balance. But what we were seeing in the example of the platforms and the attitude of companies like Glovo was that the balance was totally unbalanced, right? Like the workers' rights and the democratic aspect of the right to work was a little bit weak, on the weak side, let's say, of this balance. That's why I think the Ministry of Labor was so personally almost interested in going to the end on this. Also because, you know, the attitude of Glovo was openly challenging. The CEO of Glovo was openly kind of challenging the law. This didn't help probably their strategy midterm, but I think there was something about, you know, companies being able not to comply if they don't want, if they have the financial means to do it.
Well, yeah, it's very reminiscent in the UK of the P&O ferry scandal, where there was that open admitting of the calculus being made really about compliance and cost of non-compliance. So you've touched on this already, but eventually what does end up happening is a modification to the criminal code, which ended up being quite a powerful change to the enforcement of the law. I was wondering if you'd be able to explain what happened there.
Well, the modification of the criminal law was, you know, the government took advantage of the fact that there was a process of modification ongoing, and they modified also Article 311. Article 311 is an article with the labor law content. It's the main article in our criminal court about labor law, and it punishes the imposition of illegal conditions of work when some conditions are met. Okay, there has been a lot written about this article. What is new is that now there is a second paragraph to this article that says the refusal to comply with an administrative resolution or a judicial resolution and to maintain workers in an illegal situation under contractual agreements different to the relation of employment, to the employee, to the contract of employment, it's going to be penalized as well. This is tailor-made probably to tackle the problem we had with platforms and riders in Spain. Of course, it will also eventually protect other workers that are in a similar situation, but the idea is to punish the resistant to comply with the labor law rules. And when you read the explanatory part of this reform, it says enforcement of labor law is primarily solved with labor law rules. But as a last resort, when enforcement is not effective, criminal law needs to intervene, and that's what the legislator has attempted to do. The fact it has been very effective, because in the very moment that the CEO of Glovo was called to the clearing court, the day before, the company announced publicly that they will change their business model and change to a employee-only model. And when Uber has announced that they will also change their model, I have to say they were also under investigation. So probably they were afraid of the intervention of criminal law.
And have there been any cases that have been concluded?
No, it's still ongoing.
Yeah, so it'll be interesting to see what happens.
Yeah.
Definitely.
Yeah.
Well, I think that's probably quite a good place to round that off on. Thank you very much for talking to us about this very interesting case.
Thank you. Thank you.
And I hope everyone continues to read your blogs and your own work at the University of Glasgow. And if you enjoyed that episode, please do subscribe to our podcast. Thank you very much.
Thank you.